attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the second part in a multi-part Lawcast discussing DTC eligibility, chills, and global locks for OTC markets companies. In the first Lawcast in this series, I discussed generally what the DTC is and the basic eligibility requirements. Today, I will discuss chills and global locks. Many OTC issuers have faced a DTC chill without understanding what it is, let alone how to correct the problem. A DTC chill is the suspension of DTC services with respect to a company's securities. Those services can be book entry, clearing and settlement services, deposit services, or withdrawal services. A chill can pertain to one or all of these services. In the case of a chill on all DTC services, it is called a global lock. From the DTC's perspective, a chill does not change the eligibility status of a company's securities, just what services the DTC will offer for those securities. For example, the DTC can refuse to allow further securities to be deposited into the DTC system, or can refuse to allow the book entry trading or settlement of those securities. If they refuse to deposit securities, a person, a shareholder, would not be able to deposit securities into a brokerage account for resale on the secondary market. Although I'm sure it's unintentional, the term chill speaks volumes as to the reality of the effects of a DTC chill. A DTC chill results in the chilling of trading in a security, a chilling of any financing transactions, and a chilling of potential reverse or forward acquisitions or mergers. As a result of a complex layer of laws involving many issues, including privity between a public company and DTC, and considerations of governmental and quasi-governmental regulatory organizations, for many years, DTC refused to have any direct dealings with companies, even though the imposition of a chill or global lock had a significant direct impact on that company. On March 15, 2012, the SEC issued an administrative opinion stating that a company is entitled to due process and fair proceedings by DTC as a result of a DTC chill placed on the company's securities. The SEC held that a company is entitled to advance notice and an opportunity to address or cure an issue prior to the imposition of a chill, provided that DTC could still impose a chill without notice in an emergency situation, such as where there is a clear ineligibility or a continuous violation in process. Immediately following the SEC ruling, the DTC began changing its process and procedures for dealing with companies. Twice, DTC published proposed rules and then withdrew them. And in practice, its procedures for dealing with chills evolved fairly constantly over a period of a couple of years, with each evolution making the process more efficient and standardized for companies and legal practitioners assisting clients in resolving chills and locks, such as my firm. To simplify a complicated issue, at the end of the day, a DTC chill is resolved by a legal opinion confirming the free tradability of shares in the DTC system and the existence of freely tradable shares held by shareholders that are or will become eligible to be deposited into the DTC system. To prepare such a letter, an attorney must review the underlying paperwork and legal basis for prior deposits into the DTC system and confirm the continued eligibility of the company's shareholders to rely on Rule 144. So, for example, if the company is a shell or a former shell that is delinquent in SEC reporting requirements, its shareholders would not be able to rely on Rule 144, and continued DTC eligibility would be problematic. In the next Lawcast in this series, I will drill down further into the basis for imposing chills and locks and the process for removing them if indeed the company is eligible for such removal. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.